I am pleased to be able to share with you some of what we at the Massachusetts Appeals Court have been doing since last year's listening session and some of our plans for the future. In thinking back to the listening session last February, I'm struck by how much has changed and how much has not. We came together last year just before the pandemic disrupted our lives in so many ways. It was before the tragic deaths of George Floyd, Breonna Taylor, Ahmaud Arbery, and so many others who continue to demonstrate our failure as a society to fully confront the legacy of slavery and the continuing presence of systemic racism. And it was before the release this past September of the Harvard Report on Racial Inequality in the Courts, and earlier this month of the report by the SJC Committee on Lawyer Well-Being, summarizing the concerns expressed by attorneys of color regarding their treatment in the courts. In my brief remarks at the start of last year's listening session, I reflected on the experience a number of Massachusetts judges and court leaders had in the spring of 2019 when we traveled to Montgomery and Brian Stevenson's Equal Justice Initiative to, as he would say, get proximate in confronting our history. The listening session provided an even more important setting for that and closer to home. We heard many stories of the pain so many members of diverse communities here in Massachusetts experience in their interactions with the courts. Following the listening session, we met as a group to discuss what we all might be able to do in our respective courts. Our work at the appeals court since last year has focused on three areas. First, raising consciousness through training and internal discussion. Second, developing strategies for our court to better reflect the communities we serve through recruitment and hiring. And third, looking at how we can bring about change and shape behavior in the way we resolve cases. Let me be a little more specific about each of those. First, raising consciousness. Despite the pandemic and our transition to fully remote operations since March of last year, we have offered more than a dozen virtual training programs to all judges and staff directed to topics of racial equity, implicit bias, and greater understanding of how members of diverse communities are made to feel in their interactions with the court system. In addition, I circulated the Harvard study on racial disparities in Massachusetts courts to all judges and staff and urged all to use the day of reflection following Chief Justice Gantz's untimely death to read the report in honor of his commitment to racial equity. I likewise circulated the recently released report of the SJC Committee on Lawyer Wellness to all judges and staff, encouraging them to reflect on it as they interact with litigants who come before us. Beyond those formal programs and reports, the topic of racial justice has always been a part of our internal conversations in general and on specific cases in particular, but it has taken on greater prominence and urgency in recent times. To better reflect our community, we monitor closely the diversity of our workforce and actively attempt to identify diverse candidates to fill vacancies as they occur. We are not as diverse as I would like. In 2020, counting judges and staff, BIPOC employees, Black, Indigenous, and people of color, comprised 16% of the court overall. Judges were slightly above that at 20%. We do not control the selection of judges to the court. That is for the governor. But our interest in identifying, recruiting, and seeing the appointment of judges from diverse communities is a prominent part of my ongoing discussion with the governor's office regarding the court's needs, and the governor is a more than willing and cooperative partner in that effort. I am particularly excited about an initiative we have just begun, dubbed the Pipeline Project, focused on our law clerk program. Proposed and led by Justice Mary Sullivan and with the assistance of our law clerk program manager, Maggie Farrell, along with a number of other justices, we are holding information sessions and conducting outreach to encourage diverse law students to apply for judicial clerkships, including from law schools at historically Black universities. Our clerkship program each year provides talented new lawyers with a unique mentoring relationship with their judge and networking opportunities with each other that fosters their future success as attorneys. Among our former clerks are Chief Justice Budd herself, Justice Diana Maldonado, and Suffolk District Attorney Rachel Rollins. By attracting a more diverse pool of law clerks, we not only improve the community within the appeals court, but we send each class of new attorneys out into the profession equipped with training and a support network to help them succeed. Last but not least is our core work, resolving cases. Unlike the trial courts, we do not impanel juries, impose sentences, or set bail or hear witness testimony. But our decisions, along with those by the SJC, play an important role in setting the rules. Particularly in the area of search and seizure, we are mindful in our collective discussions of how our decisions will guide the behavior of police in the field. We also monitor situations where jurors may have been excluded based on race, or where race might have played an improper role in the way a case was handled. Even in an area as seemingly bland as zoning, we had occasion last summer to call out the Jim Crow racist origins of the term grandfathering, previously used to describe protection of pre-existing non-conforming structures or uses. The comment drew international attention to the subtle ways that racist roots may lurk behind seemingly innocent language. It has been a busy year, but our work is only beginning. We at the Appeals Court look forward to continuing our efforts and this important conversation. Thank you.